New York City's GMVA acknowledges what traditional law ignored: PTSD, trauma and delayed disclosure. Attorney Andrew M. Stengel. For decades, the legal system treated delayed disclosure of sexual assault with suspicion. Traditional statutes of limitations assumed victims would report promptly. Survivors who came forward years or decades later were often told their memories were unreliable and their delay was evidence of fabrication. The science of trauma has thoroughly dismantled these assumptions. And the New York City GMVA's Lookback window reflects a legal system finally catching up to what researchers, therapists, and survivors have known for years: how trauma affects memory and disclosure. Trauma research documents several mechanisms that prevent prompt disclosure. Traumatic memories encode in fragments, sensory impressions, emotional states, and physical sensations, rather than the coherent narrative legal proceedings expect. Avoidance of trauma related thoughts is a documented PTSD symptom and a survival mechanism, not fabrication. Furthermore, survivors often experience prolonged dissociation that prevents action, including legal action. Fear of an institutionally powerful abuser adds yet another layer of barrier that can persist for years. The neurological basis of memory gaps. The hippocampus, responsible for organizing and contextualizing memories, is significantly impaired by cortisol and adrenaline during extreme stress. As a result, traumatic memories are powerful emotionally but fragmented narratively. Survivors who cannot remember the exact date of an assault or whose accounts vary across retellings are often accused of lying. In fact, this pattern is entirely consistent with how traumatic memory functions. Memory inconsistency in sexual assault reporting is expected, not suspicious. What New York City GMVA's Lookback window acknowledges. The legislative record explicitly cites trauma science. The law embeds several survivor-centered provisions: no requirement for a police report, no requirement for criminal charges, an extended filing window, and no adverse inference from delay. These provisions directly reflect an understanding of trauma's effects on disclosure. Collectively, they represent the New York City Council's recognition that the prior legal framework punished survivors for responses that neuroscience identifies as normal. In GMVA civil litigation, PTSD serves two distinct roles. First, it explains delayed disclosure to the jury, providing the factual and scientific basis for why a survivor waited years or decades to come forward. Second, it constitutes recoverable damages, including ongoing therapy costs, lost functionality, and diminished quality of life. Expert testimony from trauma psychologists and psychiatrists can be powerful in GMVA cases, both to explain survivor behavior to juries and to quantify the ongoing harm. Common misconceptions about sexual assault reporting in New York. Defense attorneys in sexual assault cases frequently exploit common misconceptions about survivor behavior, asking why a survivor didn't fight back, why they continued to see the abuser, why they told no one, or why their account changed. Trauma experts address each of these questions with scientific evidence. Tonic immobility, a physiological freeze response, explains why survivors don't resist. Trauma bonding explains ongoing contact with an abuser. Each behavior that defense attorneys characterize as suspicious has a well-documented neurological or psychological explanation. How trauma science shapes GMV, a litigation strategy. An experienced sexual assault civil attorney builds trauma science into the case from the beginning, retaining qualified expert witnesses early, educating the jury through voir dire and opening statement, and structuring the survivor's testimony to explain rather than apologize for the normal responses to trauma. This approach transforms the narrative from "why did they wait" to "this is exactly how trauma works." That shift is often the difference between a jury that believes the survivor and one that doesn't. Building this case requires time, another reason to consult before the July 29th, 2027 window closes. Talk to the law firm of Andrew M. Stengel, PC before the deadline. Contact the law firm of Andrew M. Stengel, PC today to learn whether you have a viable civil claim under the NYC GMVA. We offer free confidential consultations and charge no fee unless we win your case. Email us at info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.